Resuming debate, the honourable member for Vancouver East.
Well, thank you very much, Mr. Speaker. And I'm pleased to rise in the House today to speak to Bill S14, an act to amend the Corruption of Foreign Public Officials Act. And of course, we're debating this at second reading, so it still has to go to committee. And I've listened with interest to the debate in the House today, and it appears that all parties will be supporting this bill, and of course we are debating it in principle, but nevertheless it is important for us to go through the bill, to examine it as we should all legislation, and of course then it will go to committee. I want to begin by saying, Mr. Speaker, that these last few weeks in the House have been particularly difficult because the government has used time allocation, a form of closure. I think we're up to time number 47 now, if I'm keeping the tab running correctly. So it's really quite incredible that so much legislation is being rushed through. To me, you know, we serve our constituents in this place. We do our work in the constituency, but our role in this House is due diligence in examining legislation and going through it. Even if we're going to support it, one has to go through it, and that's part of holding the government to account in our parliamentary democracy. So it is very disturbing that we see this pattern over and over again. It's become routine, and other colleagues in the House have commented on this earlier, that bills are now sort of just pro forma. We're expected to give a couple hours of debate, sort of a cursory look, and then there's a time allocation that going through committee, going through report stage, third reading, it's all established by timelines. That's not the way, Mr. Speaker, as you well know, that's not the way to do parliamentary business. So I wanted to begin my remarks with that because it's, you know, as someone who's been around here now a few years, I've watched the erosion of parliamentary and democratic practice in this House. And I can almost hear the voice of Bill Blakey in my head from Winnipeg, Transcona, who was sort of one of those folks in this place who had the long-term memory to know what had changed over the years. And when change happens incrementally, just a little snippet at a time, it's difficult to get that overview. And I think it would be useful one day to have that overview and to actually look at how much certain practices have changed in the House, say 10 years ago, 20 years ago. And I think we'd all be quite shocked, actually, no matter what party we belong to. So anyway, here we are debating this particular bill. And I want to begin by saying, as others have remarked today, that this bill is so long overdue. I mean, Canada has really an embarrassing record on corruption overseas in terms of lack of legislation, and many have pointed out today, Transparency International, which is a very credible organization who monitors corruption and bribery in terms of what happens in different places in the world. In their report in 2011, they ranked Canada as the worst of all the G7 countries with regards to international bribery. And they pointed out that we had little or no enforcement based on the very minimal legislation that we had. So no question that this is absolutely long overdue. And of course it does beg the question, why does it take so long? You know, you look at the legislative agenda and you look at all of the little boutique bills that come through on the criminal code when they don't need to happen. And then something as major as this that does deal with crime and corruption, you know, why has it taken so many years for anything to come forward? Where's the balance here? Where's the priorities? We're sort of pulling apart the criminal code clause by clause and adding in more minimum mandatory sentences. We've had so many conservative backbencher bills, and yet something as major as this, in terms of Canada's role in the international community, where we're hauled on the carpet by an organization that monitors international bribery and corruption, they're saying, you guys have got a pretty bad record. In fact, you're basically the worst of all of the highly industrialized countries. So, Mr. Speaker, this is an embarrassment. And to add further to that, there's only been 3 convictions in the last number of years, in fact, since 1999, and 2 of those were in the last 2 years. So this is a pretty appalling record. So, Mr. Speaker, suffice it to say, I'm glad at least that we are debating this bill today. At least it is taking some steps. And to just focus for a moment on what this bill will do for those who are watching the debate, there are four main changes to the Corruption of Foreign Public Officials Act. One of them will be to increase the maximum sentence of imprisonment applicable to the offence of bribing a foreign public official from 5 to 14 years. So that's a fairly significant change. Secondly, the bill will eliminate an exception that had been in operation for what's called facilitation payments, where a foreign official is paid to expedite the execution of their responsibilities. And I'm going to come back to this, Mr. Speaker, because there are some concerns about this, and while we agree that this exception should be eliminated, we do have to examine the impact of that on, for example, NGOs that are operating in extremely difficult circumstances in political environments that are very, very risky, where they do have to provide payments to get essential emergency humanitarian goods through, like going through police checkpoints, for example. And so one does have to find that balance. Thirdly, the bill does create a new offence for falsifying or concealing books or records in order to bribe or conceal bribery of a foreign official. So this is a very important change in terms of ensuring that transparency goes right the way down the line. And then finally, the bill establishes a nationality jurisdiction that would apply to all of the offences under the Act. And what this means, Mr. Speaker, is that Canadian nationals could be prosecuted for offences that are committed overseas. So again, that's a very important measure. I do want to say very clearly that New Democrats have long supported clear rules that require transparency and accountability by both Canadian individuals and corporations overseas. And in fact, the NDP has had a number of bills in this regard. One of my colleagues, the member for Burnaby New Westminster, has had Bill C-323 that would allow lawsuits in Canadian courts by non-Canadians for violations of international obligations. And the member from Ottawa Centre has had a Bill C-486 that would require public due diligence by companies using minerals for the Great Lakes region of Africa. Now, these are very important issues for Canadians, because we know that the extraction industry in Canada and the way it operates overseas it's a major business concern, and the way that those companies do business is something that's of great concern to Canadians in terms of ethical practices. And we've seen many movements here in Canada, many NGOs, the labour movement, individual citizens who have made sure that they became active on this issue. And I do want to point out that a bill that we voted on not that long ago, Bill C-300, it was actually a Liberal member's bill. And I raised this earlier when I raised in the debate about transparency, the Liberal member who replied to me from Charlottetown pointed to this bill, C-300, as another attempt to bring about better transparency and corporate accountability in foreign practices. What's really interesting about that bill, though, Mr. Speaker, I'm sure there are many members here who will remember that bill, is that the bill was defeated. And it was defeated in part because 13 Liberal members voted against it. I remember the bill when it came up. There was intense advocacy for the bill from major NGOs across the country. They did an incredible job. The bill itself, I think, was very reasonable. It laid out basic standards for practice. But of course, there was a lobby against the bill, and it was really quite shocking that the 13 Liberal members who voted against the bill resulted in the bill being defeated by a mere 6 votes. So we actually did come close to having that bill go through the House of Commons. And I know many of the organizations and individuals who had supported the bill were quite shocked that it had been defeated and were hugely disappointed that the amount of energy and time and effort that had gone into this. And to me, it was a wonderful example of how Canadians look beyond their own border, who looked globally to see what it is that Canada is doing. And they had paid great attention to the need for Canadian corporations and companies and businesses to be accountable, to engage in ethical practices, and to ensure that there isn't bribery and exploitative practices taking place in terms of labor rights, the environment. I mean, these are things that Canadians actually are very concerned about. And I always feel very inspired when I see organizations and people, whether they're putting out petitions, whether they're sending us emails, people really care about what we do in other parts of the world. We care about whether or not people are being exploited. I mean, my colleague from Ottawa Centre just a little while ago talked about the situation in Bangladesh. I saw the story too last night on CBC, and it's gut-wrenching, and it makes you want to jump up and say, what do we have to do to make sure that these kinds of terrible, appalling conditions no longer exist? I mean, we're talking about thousands of people who lose their lives because they work in terrible conditions where safety is disregarded, where people aren't paid decent wages. And then you layer on top of that all of the bribery and corruption that goes on. I mean, this is, I guess, a multi-billion-dollar business in terms of corruption and unethical practices. Now, this bill before us, I don't think the bill is going to address all of that, and so the other bills that we have before the House, particularly from the NDP members that I mentioned, they are critical to ensuring that there is a comprehensive approach to the way that we're dealing with this situation. Mr. Speaker, in looking at this bill, we do have some concerns about it, which I'd like to put on the record. Assuming that the bill does get referred to committee, because the bill does amend the definition of a business to now include not-for-profit organizations, we believe that this should be studied very closely at committee, and obviously witnesses need to be brought in to look at the impact on this particular change on charitable and aid organizations. Because as I mentioned earlier, the reality is that those organizations do sometimes, out of sheer necessity, have to make payments in order to expedite or achieve delivery of very essential items and humanitarian goods. This is something that is out there in the real world. Now, this bill is really tackling corruption and bribery from the point of view that money is being made and money being put in people's pockets, and officials at embassies and so on are being bribed. That's what we're trying to get at. So I think we have to be very careful that we don't, by a consequence, lay down a rule that could actually have a negative impact on organizations that are legitimately and in good faith trying to do very important work in some of these areas globally where there is political and military and civil conflict going on, and to make sure that that kind of aid is delivered in a proper way is very, very important. So we're hoping that this issue will be examined more closely at committee, Mr. Speaker. The second item that we think needs further examination is that the committee should also study the consequences of establishing an indictable offence punishable by up to 14 years in prison, because once you reach 14 years, this is actually the threshold at which conditional or absolute discharges or conditional sentences become impossible. So it's obviously a much more serious penalty, and I think that the committee, when it receives this bill, should examine that very carefully to make sure that there is a balance in terms of our judicial system and conditional sentencing or the question of absolute discharges. You know, it's easy to make kind of a blanket case, and again, we've seen that so often with this Conservative government. They tend to make harsh blanket rules that don't allow for discretion within our court system. And our court system has a history and a tradition of allowing judicial discretion so that judges can actually examine individual cases and the circumstances that warrant a harsher or a more lenient approach. That's what balance in a judicial system is about. So I think one has to be very careful that in bringing forward new legislation, we don't tip over that balance and make or create a system that becomes so rigid that it actually becomes counterproductive, in that because the penalty is so harsh that then people end up pleading not guilty more frequently, or even prosecutors may be more reluctant to bring forward charges. So there can be unintended consequences of having penalties that are so harsh. So this is an issue that we think should be looked at in the bill. We support, in principle, the the penalty being increased, the sentencing threshold being increased, but I think we have to look more carefully at whether 14 years is the right cutoff. And finally, Mr. Speaker, in terms of changes that we think do need to be looked at, we want to look at the question whether the rule on the facilitation payments that I spoke about earlier, whether or not it needs, once we figured out how it impacts NGOs and nonprofits, then there's an issue as to why in this bill it wouldn't be part of royal assent. It would rather be under the consideration of Cabinet. That's what's in the current text, Mr. Speaker. So that one aspect of the bill, if this bill were passed as it is, basically, it wouldn't go ahead with the rest of the bill. So I do think that has to be examined. We need to know the reasons for that. Why is that being put aside? And maybe the discussion on the facilitation payments as it impacts NGOs might help inform that debate. But it is something that we need to look at. Mr. Speaker, I do also want to talk briefly about more current situations. We heard today from the member from Ottawa Centre who updated the House on a communique that he had received from the G8 that's currently taking place. And it was quite interesting because he pointed out to us all that in this communique, the issue of corruption and transparency was actually quite prominent in the communique. And his point was that we need to know that our own government is committed to not just the words that are in these communiques, but we're actually going to follow up. And I thought he used a very good example where he spoke about international treaties that we sign, but there's no follow-up. And in fact, the example that he used was Bill S-10 that was rushed through this House just a few days ago. I was one of the people who spoke on that bill to do with cluster munitions. And he pointed out very clearly in the debate in that bill that many of us, well, all of us in the NDP, we believe that the bill S-10 actually undermined the very international treaty that it was meant to be following up. And so the point here is that when these communiques come out and when these commitments are made in places like the G8, we need to know that they're actually going to be followed up. We need to know that those commitments actually mean something. And again, we get back to this particular bill that has taken so long to come forward, S-14. Why does it take so long? Why isn't there a greater priority and emphasis on these kinds of bills? In the G8 communique, some of the issues that were flagged was the need to have greater transparency, the need to have a public registry. And the member from Ottawa Centre told us that one of the proposals is that there needs to be a regime whereby companies won't be able to set up a shell company. So that even if you have good legislation, if you can't enforce it, well, possibly because there's a lack of political will, because I've just spoken about, but secondly, because then trying to figure out who actually owns, who are the operatives in a particular company, if there is enforcement to be taken on issues of bribery and corruption, then it makes enforcement very difficult. So I think the idea of a public registry, the idea that we need much better transparency, and the notion that we shouldn't allow elaborate legal complexities to set up shell companies that in effect allow people, individuals, and operatives to hide behind other entities that make it much more difficult to figure out who's doing what and where enforcement should be applied. So I think that's a very significant issue. Now, of course, Mr. Speaker, it's not covered in this bill, so it does show us that this bill doesn't go far enough, and I think that was the member's point this morning. Nevertheless, we are supporting this bill at second reading. We will pay great attention to it in committee, and we will seek to improve the bill so that it lives up to its spirit and intent, and that is ensuring that we tackle bribery and corruption by public officials in other countries. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.